An Accra High Court has rejected the West African Examination Council's application for a stay of execution concerning the order to release withheld WASSCE results on December 30th, 2024. WAEC announced the withholding of results for approximately 10,000 WASSCE candidates across various subjects, citing alleged involvement in examination malpractices. On January 30th, 2025, the court ruled in favor of 4 students representing all affected candidates who had petitioned for the release of their results. Now, despite the ruling, WAEC filed for a stay of execution pending an appeal. However, during a hearing on Thursday, the court dismissed the application. Well, Head of Legal Affairs for WAEC, Reverend Victor Brew, and the legal representative of the affected students, Martin Pebu, joins me live on Zoom with more. Thank you so much, gentlemen, for your time. I'll start with you, Reverend Victor Brew. You plan to appeal the High Court's ruling?
Well, good morning to you and to your cherished listeners. Yes, if you put it that way, we plan to repeat the stay of execution in the Court of Appeal, which is part of the entire court process. So if you went to the High Court and it gave a ruling or a judgment and you first, apply for stay of execution in that same court, if you are a lawyer of rich experience, you will know that it's more likely that the court will not grant the stay. But then that is the rule. So you do it, and then if it's not granted, you have the option of either complying with the ruling of the court or repeating the application in the Court of Appeal if you really believe in your case. And so we are going to explore that option. But first of all, we need to get a hard copy of the ruling or the judgment, if you like, and then we will actually then likely repeat the stay of execution in the Court of Appeal, yes.
But at the center of this legal tussle are the lives of children, about 10,000 of them, who are unable to go to school as a result. What exactly is the difficulty in the WAEC releasing the results?
Well, I'm not sure it's about difficulty. It's actually about the fact that WAEC is still working. And so even as these candidates who are 10,000 over went to court, there are several candidates, others whose results have been worked on. And I can tell you that even as my colleague on the other side led his clients to court, we were not constrained by the very act of going to court from working on other results. And we have been releasing results, exonerating some candidates, canceling the results of others. So it's really this group of students who've taken us to court, and it's their right to take us to court, no qualms. It's also our right to also respond, no qualms. So for us, the process is just ongoing and there is no tussle. It's just that in a democracy, people have a right to ask why we took this action. If they are not satisfied, they can go to court. Nobody should stop them. And we also have the right to also respond to the court and exhaust all the processes. That is what it's really about. It's not about a tussle. And then it's also about our children and the entire society getting it clear that no matter what happens, we will have to uphold the integrity of the results of exams. We should not be pushed into a situation where people would cheat, have their results withheld for further investigation so that you don't cancel the result of an innocent person or let go the results of somebody who has cheated. That is really the process. And so whilst we are doing that process, I think that no amount of media, court action or demonstrations should cause us to release the results of persons who have cheated. So yes, we can talk about the length of time, which WAEC is willing to look at, perhaps the length of time. And we are saying that with more resources, we can do this work, maybe more speedily, if I should put it that way.
Victor, please stay with me. I'll come back to you as we wrap up the conversation, just get your final thoughts. But let me bring in lawyer for the plaintiffs, Martin Pebu. Thank you so much, Counsel, for your time here on News 6. Now, you must be pleased because the High Court rejected WAEC stay of execution application. But then we're just hearing from Victor Bruce served notice that they will be appealing that decision. Your initial reaction?
I'm disappointed that Mr. Brew would want to continue, or let's say Lawyer Brew, this is a lawyer, would continue abuse extra. Enough is enough. Enough is enough. You see, the problem is that WAEC is not realizing that we are dealing with this matter in a constitutional context as well. So the Constitution, Article 23, requires that administrative bodies act fairly and reasonably. Fairly and reasonably. So, my sister, as we're speaking now, more than 1 month on, WAEC is not able to tell my clients, you, Esumesi or Benteng, you copied, you had foreign material, etc. They are not able to tell the specific crime. WAEC is engaged in speculative, let's say, cancellation of results. I'm telling you that we went to court and finished this court matter. WAEC could not produce one charge, a single charge against any of these students. So it's just not on. The Constitution says WAEC must act reasonably and fairly. Where is the reason and where is the fairness? When you keep counting somebody, you keep counting the person that he's engaged in the examination malpractice. Then sometimes you say examination irregularity. Meanwhile, you cannot tell specifically what the person did. What is the candidate's charge? Ask Lawyer Brew. Where is the charge? I had a meeting with Lawyer Brew before we came into court. We're in court for 3 weeks. Court is done. They've not been able to stick a single charge on any of my clients. 10,522. Not one single charge. Please, let's use the Constitution.
Now, let me bring in Victor Brew at this point in time, just to get responses for Lawyer Martin Pebu. Lawyer Martin Pebu is concerned that you have not put forward not a single charge against his client, over 10,000 of them. The law says you must act reasonably and fairly. Martin Pebu says you are breaching the law.
Yes, thank you very much for putting that question. I don't agree with my learned friend on the other side. The point is this, that we usually would upload the results. Candidates will see against their subjects withheld, and then candidates would have, even prior to taking of the examinations, been made aware of the rules regarding the examinations, that if you copied, if you brought in mobile phone, if you did XYZ, this would be the likely consequences. So it's not as if they don't know the rules right from the get-go. So they know the rules. Yes, but
he's concerned that you haven't charged any of his client. He says not a single charge.
That is not wholly accurate. I must say that we have written to the various candidates and indicated that, look, your results in, let's say, English or maths, you would have checked and realized that maths has been withheld, English should have been withheld, and therefore you should come and respond to issues of examination malpractice in maths or English. Perhaps maybe what he's talking about is to say that, specifically to say collusion, or to say you brought in mobile phone and so on and so forth. That we can, we can say, yes, we could be more detailed with that. But as to whether they didn't know that the issue has to do with, let's say, malpractice in English or maths or XYZ, that will not be wholly true. So we can look at being more detailed with the specifics, I must say, but not to say that they are totally unaware of what the issues are regarding particular subjects.
Counsel Martin Pebu, let me come in at this point and just get your initial reaction. Are you pleased with Victor's response?
Absolutely not. Absolutely not. So you see, he's considered that they've not been able to give us the specifics. You see, he's considered. And now the action is over. So with the court action over, that's the judge saying that they must release the results, they can no longer try my client. No, the matter went to court. If they had any charges against my client, they were supposed to bring that to the court so that the court will see that, oh, this is an ongoing process, so please, Pebu, you and your 10,522 candidates, go back and answer. But throughout, they couldn't levy any specific charges. So the judge said, oh, that's not our law. So please, why it release? So let's be very clear, madam. Your news should be that WAEC doesn't have jurisdiction to try my clients again because we've gone to court and finished. A court order has been made. So WAEC can continue. I understand WAEC continues to invite candidates to come. My candidates are not passed. If WAEC invites any candidate, any of my candidates, will be compelled to bring an action in contempt against WAEC because the court order is being made. The judge has held that WAEC has no key to release the results. So WAEC cannot invite my clients again.
Let me finalize with Victor Brew. You've heard Martin Pebu. You want to appeal the case. What's your response?
I must correct something. I respect lawyer Martin Pebu's standing in legal practice, but unfortunately, I'm not able to agree with him on the tangent he's moving. He knows very well that in court practice procedure, you cannot say that because a court has given a judgment, therefore you should just comply with it. He has been practicing for years. I expect him to educate the public accurately that WAEC has a right to repeat the stay of execution in the Court of Appeal. Leaving this information out, with due respect to my learned friend, is rather not, I would say it's disingenuous, to say the least. He should educate and educate well so that his clients don't have an impression that the process has come to an end, leading them to, they then going haywire. That is not right. My friend, Mr. Martin Pebu, I feel you should educate well and tell the public that WAEC has a right to repeat the stay of execution application. And if it's not granted, then the process continues, but not to give the impression as if this is the end of the road. That is not correct.
Thank you, Reverend Victor Brew. He's head of legal affairs for WAEC. Joining me earlier was Martin Pebu. He's legal representative of the plaintiff.